Let us get down to business now with a very warm good morning to all of you. I formally welcome Mr. Bhagwan Das, our online friend who has joined from Pakistan. We were deliberating the idea of constitution drafting, constitution designing. This is our second most important engagement in week second. And today I propose different dimensions, including preamble, what exactly is the concept of preamble, why there is a necessity to have a preamble to the constitution. Not only it is relevant in case of constitution, but it has also become a fashion whenever we try to contemplate ourselves as something in black and white to transact different businesses,
Hello, good morning, sir.
societies, and other
Can you please
important
hear me?
functions. We try to understand that there has to be some kind of a mechanism, there has to be some kind of a charter, there has to be some kind of a understanding, and these understandings are reflected in the form of a preamble. So preamble constitute a very important dimension of constitutions, and there has been an importance of preamble because the constitutional preamble eliminates the great variety of, or rather I should say, that constitutional display. There are different vertical notions, different contemplations, different vertical variations, and lot of dynamism is also reflected in the preamble because been some constitutions are basically constitution. What we call understood, what we call pristine as well as
Sir Noid, what happened? Hello, Mr. Naveed.
Yes, boy, I can hear you.
Where is sir? Where is sir?
I think he's gone. He had some issue with the I think connection. I thought that the issue was with me, but then okay. Yeah, I got your message. Am I
Yes,
audible,
yes,
Vedant bhai?
it's audible.
तो आप स्विच कर सकते हो, मैं तो इसका स्लो चल रहा है ना, आप
नहीं, I will, मैं हर बार आप ही को बुलाऊंगा, right? I don't mind. Anyway, it has been. Well, I apologize, my dear friends, particularly the online guys, because of the some technical glitch, we got disconnected. Now the connection has been restored. Am I audible to all of you?
Yes, sir.
Yes, and now you're audible.
Yeah. Thank you. So basically, I was, and the point is, that we should not accept the idea of constitutionalism on the basis of a face value of a constitution. Being a student of comparative constitutional law, it is our fundamental responsibility that we should try to understand the nature of the constitution from the preamble. Whether we are studying the Constitution of United States of America, Constitution of South Africa, Constitution of Malaysia, Constitution of Australia, Basic Law of Germany, which is popular, they generally address their constitution as basic law, the Constitution of Italy, Constitution of France, Constitution of Afghanistan. Unfortunately, we don't have any constitution right now, or rather, the constitution Afghanistan is emerging another important what we call nation with an unwritten constitution, I should say, because there is a variety of what we call reasons. I would also be explaining, because I would be explaining on the basis of Afghan scholars, and their writings are in public domain, how this idea of constitution is being what we call received, appreciated on critical footing so far governance in Afghanistan is concerned. So my dear friends, I was making a point that there is no requirement of looking beyond South Asia to have a correct understanding of the preamble. It's available within this South Asian trajectory of constitutions. We are having republican character of constitutions. We are also having the theocratic character of constitutions. We are also having the democratic character of the constitutions. We are also having the secular what we call values incorporated in the preamble to the constitution. All sorts of what we call flavors so far the preambular propositions are concerned available in the context of South Asia. There are as many as 4 Muslim majority nation states in South Asia. Number 2, there are Buddhist majority nations in South Asia. There are Hindu majority nations in South Asia. So all kinds of characteristics in terms of the religious flavor, we are having this. I mean, we are having constitutions of all sorts in South Asia. If you take into account the 2004 constitution of Afghanistan, it was basically framed as the Islamic Republic of Afghanistan. Now it is Islamic Emirate of Afghanistan, which is invoking, or rather recently invoked, 1964 constitutional provisions from the constitution that was drafted as a monarchical constitution in 1964. Some of the portions, some of the provisions have been invoked for the temporary governance of constitutional affairs, so transacting constitutional what we call business in Afghanistan, and some of the provisions of 2004 constitutions are also what we call reflected in the functioning so far their international posturing is concerned. Otherwise, or let me put it like this, in entire world, no constitution is a satisfactory constitution. No constitution provides any kind of a gospel gratification to the people. No constitution is capable to cater each and every what we call demand, can address each and every what we call expectation. Same is the case with me. Even in the field of higher education teaching, I cannot claim myself, or Nafis cannot be a panacea for everything. Despite the fact I am dealing with this particular paper, that is the comparative constitutional law of our nations, for the last 12 years. I have been dealing with this particular subject. Even then, I cannot claim that I know comparative constitutional law. If I today make this particular claim that I know constitution or comparative constitutional law, it means I am basically establishing the disintegration of my what we call intellectual understanding. I am basically facilitating my decline. So I cannot claim that I know comparative constitutional law with due apology and due regards. And for the last what we call more than 25 years, I have been teaching constitution. For the last 12 years, I am having a different kind of a what we call flavor, or different kind of a program, a specialized program, that is comparative constitutional law of SAARC nations. And in Aligarh Muslim University, I was dealing with federal constitutions of the world, major federal constitutions like France, Switzerland, South Africa, Australia, US, and other nation states. But I cannot claim that I know federalism, I know constitutionalism, I know other important nuances of constitution, because law is dynamic. We cannot claim any kind of authority. Yes, that is why we use, not only I, but majority of the scholars, majority of the students, they generally use the word within inverted commas, student. I am a student of international refugee law, or international constitutional law, or comparative constitutional law. So the idea of a constitution, my dear friends, when I studied 2004 constitution of Afghanistan, then it was, I feel, this is my well-considered opinion, though it has been what we call, adopted on the basis of what we call Bonn talks, which took place in Germany in 2003, and that has been. And it was one of the arguments advanced by current regime Taliban, that it was an imposition, an American imposition upon Afghan people. My friends from Afghanistan can correct me if I am what you call having any sort of, shortcoming or deviation from the real, argument, the real political, scenarios. So if you take into account the preamble to the, constitution, then it was basically established as a Islamic Republic of Afghanistan. But as a student of, constitutional law, I find nothing Islamic in that very, constitution or constitution of 1964. Same is the situation with that of, constitution of Pakistan, which has also been branded as the, Islamic Republic of Afghanistan. I find this republic is away from Islam, and there is nothing what we call, Islamic. Same is the, situation. We can also extend this argument. So far, the nature of the, constitution is, concerned. Take the example of the Indian Constitution. Constitution, it's a, Republic of India. Sovereign, secular, socialist Republic of India. So you can very well understand, you can test these preambular propositions, what kind of a nomenclature has been, there that, defines and determines the nature of Indian polity. So far, the governance in this country is concerned as per, constitution. So you can very well understand to what extent it remains, secular, to what extent it is democratic, to what extent other important, features are reflected as per the, mandate and message of the preamble to the Constitution of India. Likewise, you can also understand the preamble to the Constitution of, Bangladesh, or the preamble to the Constitution of Sri Lanka, or Bhutan, or Maldives, or Nepal. Whether the governance structures have been successful in reflecting upon preambular propositions, whatever has been, promised by the, constituent assemblies or the respective, constitutional assemblies. So, despite the fact we have adopted different what we call, styles, different what we call, we have also adumbrated different functions of the, preambles, and the law is also settled that the preambles all over the world to the constitutions are generally construed as an essential, integral, and pivotal part of the main body of the, constitution. Because the preamble, as suppose today we try to start a research paper, we try to draft really catchy what we call, topic, and we also try to write an abstract. And on the basis of, abstract, or before writing abstract, we try to, draw some kind of synopsis. That this is going to be the, main points or the major points or the minor points in the form of a, synopsis. And on the basis of that very synopsis, we develop some kind of a, hypothesis, write an abstract, and thereafter we start writing a research paper. So, my dear friends, the preamble to the Constitution is a kind of a synopsis. It is the introductory, or that is why it has been, the expressions like that the preamble is a key to the Constitution. A famous traditional conventional understanding. It is basically the preamble and the goalpost dreams and ideals which have been incorporated in the preamble. These, ideals establish what kind of a polity we are going to have, what kind of a relationships, whether it is going to be a federation, so far our geopolitical entity is concerned, whether it is going to be a federation, whether it is going to be a unitary unit, whether it is going to be some hybridization kind of what we call of, state, whether it is going to be a hermitocracy, democracy, nomocracy, oligarchy, monarchy, whatever may be the, nature. So we basically try to understand this particular, idea from the preamble to the Constitution. Same is the situation with the preamble to the international organizations. You can take the example of the United Nations, what we call, charter. That when it was, drafted after various what we call, conferences, up to the last one, that is the, Yalta conference. And it was, inaugurated at San Francisco on 24th of October in 1945. So you can very well understand, my dear friends, what kind of, preamble has been what we call, assigned to the entire what we call, charter as a multilateral organization. How it has visited the different what we call, aspects of different, geopolitical entities. Whether it was basically, it is altogether a different question. You may agree, you may not agree. I do not agree with the mandate of the United Nations Charter and other important what we call multilateral organizations. On some other occasions, definitely we are going to deliberate. Because still, I feel, despite the fact we are having two important what we call, documents in the history of humanity so far multilateralism is concerned. The Charter of League of Nations and the Charter of the United Nations Organization. During the operationalization of the League of Nations Charter, we have witnessed a colonization in Africa. Even today, we are also having imperialism with a different kind of a nomenclature like globalization. Why these institutions of a multilateral character are being proposed or have been proposed as a extension of the colonialism with a different kind of a nomenclature, with a different kind of a flavor. Why United Nations organizations has become some kind of a euphemistic Western organization or Western what we call project. Because nothing is being what we call transacted under the auspices of the United Nations organizations, despite the fact we are having rogue regimes, we are having what we call regimes of concerns, we are having regimes which are not what we call conforming to the mandate of the preamble to the United Nations Charter. Still, international issues are being debated not under the auspices of the United Nations organizations, rather some other, regional organizations are calling the shots in the corridors of power, like, NATO, a military alliance. Now, today we are, talking of the NATO plus what we call, people are, the NATO leadership is, talking, let us have some kind of, expansionization of this kind of, security narrative. They are coming out with other important what we call alternatives from Asia. Asian nation states must also be made a part of what we call of the NATO organization. Some other security what we call groupings must also be established. Silk Route, that is what we call Belt and Road initiative. A new kind of a Silk Route is being established. Was it necessary to have this kind of a organization, or is it okay to have the regional what we call groupings? We are also having a regional grouping, and to what extent it is all. It is basically the responsibility of we the people of South Asia to evaluate to what extent the SAARC grouping has been successful since its establishment in 1985. We have to take into account whether it has been able to deliver what has been what we call desired by the collective wisdom of 7 nation states and 7+1, and 1 is Afghanistan, because it was the last member after the operationalization and of SAARC nation state or the SAARC what we call grouping. It was admitted at a subsequent stage. So in such a scenario, my dear friends, what is the importance of preamble? Why we are having preamble? Because this is a very, very important concept, and that concept must be understood in its totality. While their use and significance have increased in recent decades, so far preambles are concerned, the constitutional preambles have received only scant attention in academic literature. You will find very few what we call writings, and whatever the writings are available, definitely I am going to share. There is a need, therefore, to have the quantitative and qualitative analysis of all the preambles currently in force around the world. And particularly, it would be my recommendation to all of you, my dear friends, try to evaluate qualitatively as well as quantitatively the significance, the mandate, the message, the relevance of all the preambles to the South Asian constitutions. You may write, either you should go for a blog, you may also produce a research paper on this particular gray area, because no work in the real sense has been done in this particular connection. So you may also jot down, whenever you find time in your life, you should also revisit this particular gray area, because this is the responsibility of all of us. Because the study of the preambles not only helps, my dear friends, to understand the phenomenon itself, but also teaches us more about constitutions and the constitutional systems in which they are generally what we call located, situated, and adumbrated. So that particular gray area must also be understood. So this is the importance of the preamble, my dear friends. So how and under what kind of understanding we generally attribute to the preparation and to the evolution of preambles. What has been your experience? You can share. What is the importance of preamble? Yes. Please, hold your horses, please. I'm not discussing here the borrowings, transplantations, or constitutional transplants. No. I do not accept this kind of remark. I take it as an allegation against the Constitution of India or against the Constitution of Afghanistan. No. Tomorrow, even the Nepalese constitutions may be subjected to this kind of hybridization. That this portion has been taken from this constitution, and that particular portion of the constitution has been what you call taken from this. No, that is not the case. Yeah, please. Yeah. Continue.
Yes, between the people of India, there is the people of India. Peoples is not a plural form of people. Peoples has another meaning. Like whenever we talk the people, like here in classroom, there is some is Hindu, some is Muslim, some is white, black, combination. So whenever there is some people, there is a unity amongst the diversity. But when we use the term peoples, it means that there is only one identity. Irrelevant, irrespective of their community, their nationality, their white, black, color, nothing is relevant when we use the term the peoples. So the meaning of peoples of United Nations, this entire world has only one identity, that is a member of United Nations. Whereas when we use the term people of India, it means that we have different, we have the same identity, different diversity. So it's a development. So people of India, like the term peoples of the people of India, developed form of the community. This has been expressed by the Antonio Guterres in the recent, in the previous year, public conference.
He is not the first to explain this. He has also echoed somebody else what he call words. Yes, you are right. My dear friends, when we use the term, these kinds of expressions in the schematization of the United Nations Charter Preamble, We the peoples means we the nation states. Basically the peoples, and it is not the first multilateral organization. Even if you study another important, in the context of Africa, if you see the title of 1969 Organization of American States, Convention on the Peoples and Human Rights, People's Rights. It means entire Africa has been, taken in the title itself. So far, this, convention is concerned. OAU convention, we generally call it. So it uses the word peoples, not people. So entire what you call, nation. I mean, whatever the, nations are, there are as many as 52 or 53 nation states in entire, Africa continent. So this entire, cluster of nations have been addressed in this, convention as, as peoples. Same has been the case with the preamble to the United Nations Charter, as you have, pointed out. But so far, the people, we the people of India, this expression is, concerned. Though the idea is, unity in diversity, but that has also been what you call, question, because it has taken a different kind of a, shade. Unity in diversity has become, for some scholars, unity with diversity, not in diversity. That is some kind of a juridical shift, some kind of a, a new kind of a narrative is emerging, because the people of South Asia, the people of, Pakistan, people of, India, people of Nepal, they are basically coming out with this kind of a, how we are going to appreciate a diversity. This must also be, reflected in the preambular propositions, because it is basically, as there is a unanimity, there is a consensus among all of us that the preamble is basically an idea that establishes what kind of a constitution we are going to have, whether it is going to be a theocratic constitution or religious, constitution, or having some kind of a religious, what you call, clauses, as it has been, witnessed in Muslim majority nation states. Sharia law clauses has become rampant in all the, religious constitutions designed by the Muslim majority nation states. So that what we call, Sharia laws is always, there, and that is why it becomes relevant that we should also take into account what kind of, constitutions are there which have been specifically, promulgated, enacted by the Muslim majority nation states in South Asia. Yes. Who will respond? Yes.
Unity in diversity.
Speak a little bit loudly. And for a while, you may also remove your mask, if it is possible. You are vaccinated?
Yes.
Yeah, good.
So unity in diversity, if you look into the preamble of Nepal, even they are promoting socialist economy, and we are also progressive in the sense that we want a diversified federal state. And when we talk about unity, the first one is unity. Yeah, I explained about unity in diversity. And the second was unity
With diversity.
It's like, it's the same thing, but the essence of the sentence is, it comes out different when we apply it through preamble. I find that.
Let me. I will use only two words. I will use the word assimilation, and the second word would be integration. These two expressions, I may be wrong. I'm not at all. I generally do not prescribe anything, right? So you are free in your intellectual domain to disagree with me. Unity in diversity basically takes into the idea of assimilation, where caste distinctions, racial distinctions, religious distinctions generally get blurred. We do not have any kind of a conspicuous visibility of these distinctions, these dichotomies. That is the idea of what we call of unity in diversity. As per my understanding, you can correct me, Ms. Bakshi. The second word which I am using, the word integration. Yes, we are the part of India, we the people of India, but we are going to maintain our distinct identity, and that is diverse. And there is no possibility of assimilating my identity with the identity of the rest of the people. That is my understanding. Integration. We are the part of India, we are equally loyal, we are equally patriotic, we are equally what we call, American, to all kinds of what we call. Because unity with diversity creates a multi-layered identity. Unity in diversity does not have any kind of a horizontal or vertical what we call fragmentation. We cannot have some kind of a horizontal juxtaposition of our identity. In case of unity in diversity, but so far unity with the diversity is concerned, it is having a national sense of integration, a national sense of patriotism. Both the features are having, both of what we call narratives are having, but there is no dilution, there is no assimilation, and that is the beauty, because that promotes a diversity, multiculturalism, and pluralism. And of late, what we have been witnessing, that these kinds of ideas, these kinds of fundamental principles have been what we call targeted, and they have been what we call discarded. Otherwise, if you take into account the federal constitution of France or the federal constitution of Canada, you will find that they generally celebrate the idea of what we call of the so far their national identity is concerned, they celebrate the idea of secular state. At public places in France, they try to maintain only a unified identity. In Canada, it is the Canada identifies itself with the idea of multiculturalism. Same has been the case with that of the United States of America. Racial discrimination, the cases of racial discrimination, the cases of religious identity in Australia and in United States of America, the issues of what we call of beard, the issues relating to what we call burqa in France, the issues of what we call of mosque minarets of the mosque in Switzerland, the issues relating to the Sikh turban in United States of America and Canada. That is why I am using the word unity with diversity. Unity, not in diversity. So I am basically bringing for your consideration the global what we call scenario, beyond what we call our nationalistic affiliations. Yes, we the people of India, yes, within the Indian context, we try to emulate, we try to subscribe to the idea of unity in diversity, but let us have, as a student of what we call of comparative constitutional law, a global picture of this narrative. Then globally speaking, it becomes, my dear friends, a unity with diversity. Because we cannot ask in United States of America or in India, Indian armed forces, we cannot ask a Sikh, please remove your turban. No. We cannot ask a Muslim, a practicing Muslim, so please, you should not sport beard. We cannot ask. So these are some of the important, what we call, facets. We are having an idea of what we call, so far India is concerned, we are basically having the idea of religious tolerance. That is why, my dear friends, in many what we call, state institutions like police stations, we find in a corner even temples. We find even so many what we call, some kind of a, house where all what we call religious, deities have been placed. That is why it becomes necessary, my dear friends, to understand that what kind of a, idea, so far the preambles are concerned, and that is the importance of preamble, because it is preamble, I think, in other words, let me put it like this, that the preamble constitutes the kernel of the constitution. We cannot run away, we cannot discard, we cannot abandon the idea of what we call a preamble to the constitution. It is very, very important, and without which we cannot, or a constitution can't survive. That is my understanding as a student of comparative constitutional law or constitutional law per se. You got every right to disagree with. You can also offer your alternative views to my argument. And that is the beauty of, research-oriented intellectual engagement. Because if I am addressing 27 students right now, offline and online both, it means we are going to have 27 alternative views on a particular issue. So how can I, discard? I should not. Rather, I should enrich my what we call, understanding on preambular propositions. What is your understanding? What exactly should be the preamble as per, Afghan orientation? Because Afghanistan is a country where they would prefer the preamble to the constitution of Afghanistan should begin with the idea of Bismillah ar-Rahman ar-Rahim. In the name of Allah, the most beneficent and merciful. If you see the judgments of Justice V.R. Krishna here in India, or you see the judgments as well as the juristic writings rendered by Justice Kartaju, you will find a lot of shlokas from religious scriptures have been cited. If you take into account the judgments delivered by the highest judicial establishment in Pakistan, then the judges on many occasions resorted to some kind of a shairi rendered by scholars like Dr. Sir Muhammad Allama Iqbal, Ghalib, Mir, Josh. They have, on each and every, point, suppose on equality. I can quote a couplet, I can take a couplet from, Shikwa, Jawab-e-Shikwa, complaints and answers to complaints, written by Allama Iqbal, where he was, basically addressing a question relating to equality. एक ही सफ में खड़े हो गए महमूद और अयाज, न कोई बंदा रहा न बंदा नवाज. Mahmud means the king, Ayaz means the ruled, the general masses. Kings and ruled stood in one file, and there has not been any kind of subordination among them. And the best English translation that has been rendered by Khushwant Singh of this particular, whenever you find time, you should study Khushwant Singh, because, my dear friends, remember one thing. Once, when Indira Gandhi, the late Prime Minister of India, was speaking in Parliament, and this is the part of the parliamentary process, and she was of the view, what are the attributes which constitute or which makes or which make a good citizen, a good politician, or a good what we call minister? Then the late Mrs. Indira Gandhi identified as many as 4 or 5 subjects. She identified law, political science, history, philosophy. These are the 4 subjects which she has identified as the primary history. And she came out that all of us, and another one is literature, any literature. It may be what we call English literature, Urdu literature, French literature, whatever, English literature. And my dear friends, so far literature are concerned, South Asia is very rich. In South Asia, we are having the richest literatures. Literatures like what we call, Malayalam literature, Tamil literature, Telugu literature, in our part of the world. Urdu literature is an amalgamation of, literatures. So you can understand, my dear friends, many of the, legal points have been crystallized by the judiciary by invoking these what we call, couplets, shlokes, and other important what we call assignations rendered by, literateurs, jurists, thinkers, philosophers, guides, and other important, personalities. And that is why we can say, on the basis of our, deliberations, that preamble to the Constitution is basically the gist of entire, Constitution. Preamble to a Constitution is a reflection, is a manifestation, a cumulative reflection, an amalgamated what we call, reflection. This is the crux of a civilization. So the preamble to the Constitution of India reflects the 5,000 years old Indian civilization. Basic law and the preamble to the basic law in Germany is basically takes into account the entire existential what we call civility in the history of Germany, when it used to be what we call Germania. If you take into account the constitutional conventions in UK, that is also a reflection of what we call an amalgamated what we call form of constitution. It takes into account Wales, it takes account Ireland, Irish values, Scottish values, Midlands, England, and what we call Eastland. All kinds of what we call, you can see the entire what we call amalgamation is reflected in these constitutional conventions. And how? See the solidification, entrenchment, embeddedness of these constitutional conventions in the life of the British. There is no requirement of any kind of amendment or deviation or derogation from those constitutional conventions. They are reflected. So if you take into account these notions, you can understand, my dear friends, that this is the importance of preamble. So cumulatively, if you create today a synthesis what actually and what we have understood out of this deliberation, then we can say that the preamble is the culmination. It's a kind of a inculcation of our civilizational what we call journey or civilizational peregrination in a geopolitical entity. If today we are having this sort of preamble, it is a reflection of the collective wisdom of the people of India, who have been represented in the Constituent Assembly, as well as the amendments, whatever the amendments have been carried out under Article 368 of the Constitution of India, under the doctrine of amendability. That is a reflection of the collective wisdom of entire what we call people, we the people of India. So that is a reflection. So the preamble to United Nations Charter, preamble to the League of Nations Charter, preamble to the ILO, preamble to the United Nations Human Rights Council, to a preamble to other important international organizations charter, It is basically a reflection of our collective wisdom at international level. And at the same time, because at international level, we generally resort to people, not, I mean, peoples, not people, as our friend has rightly, pointed out. So, my dear friends, this is my, submission that it is a culmination. It is the inculcation of our, civilizational resolve, which is reflected how we are governing, going to govern, or have been, governing ourselves in a what we call, time frame. Now, how to design? What has been the, journey of, designing Islamic what we call, constitutions? If you take into account the past trends and democratic future options which are available to the, Islamic nation states in South Asia and beyond South Asia. My dear friends, the first Muslim constitution was promulgated by the Holy Prophet of Islam, Prophet Muhammad, peace be upon him, when he migrated to Medina and foundation was laid for the government of a city-state. The first constitution came into existence. I will supply, please do not try to understand. I do not encourage my students to write or jot down something. If you feel some of the important, because whatever I am speaking, everything is not written before me. Right? Some important points are there, and these points I have elaborated in other forms, in the form of articles and other important what we call material. That material I am going to share with all of you. So please, whenever anything is shared with all of you, try to study that. I have whatever the requisite material was, I mean, from your examination point of view was available, I have already shared with all of you, emailed you. Whenever you visit the class, please, you should study that. And at the same time, if something you come across which has not been shared by me, you should also share that particular argument with me, because as I have already said that I don't know anything about comparative constitutional law. So with this what you call note of caution, I generally make my submissions, because I am equally selfish, but I am not self-centered, because I am using a positive word, selfishness. That is a very positive word, and the negative word is self-centered. One should not be self-centered. Selfishness is okay, no problem. So both of us, this side and that side, both the sides are complementing each other, and we are here to create the new what we call understandings, new what we call juridical goalpost, and new intellectual freedom on a particular point. So what is your understanding of a preamble? Yes, Ms. Bakshi, you are smiling, and these masks has really provided a cover to hide your smile.
So I think the preamble text past historical struggles of a country, present ideas of the draftsmen who are drafting the constitution. For instance, in every constitution, you will see that they have established themselves as a sovereign nation. So that is something which is very common. So that is the present idea that at that point we are sovereign for the rest of the life. And the future aspirations of what the people expect from them. For instance, in Pakistan's preamble, there is a mention.
Whatever is mentioned, share
Yeah,
it, please.
it's mentioned that in furtherance of the declaration UDHR, the term UDHR has been mentioned that our human rights.
It is Afghan Constitution of 2004 you are talking about. It is Article 7, yes.
So
Where it has been explicitly mentioned.
it's also mentioned in the preamble.
Yeah, preamble.
So that shows the future aspirations. It's a combination of the past and the
Yes, yes.
we had 7 different constitutions with 2 different governance systems. We had autocratic constitution, we had compliance system, we had monarchy, and now we have federal they're a Republican. Before joining this class, maybe it's because I'm atheist, I mostly believe that religion was a great feeling, a great- I never believed that religion could have so much effect in others' life.
If I start expressing myself, my religious view,
Yeah,
definitely I may be granted, I may be setting some markers.
yeah, now, but now, but now I've been here, I've never had Muslim friends, I've never had Christian friends. So it was very, process understanding varieties of culture and diversity. Now that I studied Afghani, both of the and I compared Bangladeshi and they were quite similarity. I always thought that constitutionalism, principle of constitutionalism was the basis to have a preamble. But after I read some of the other preambles, I felt that religious stability.
Rather, in other words, let me put it like this: the preamble of the Constitution should always be understood on the basis of pains and sufferings.
I'm still processing.
And I hope, and I understand, your pain is not different from my pain.
The
Right?
thing is-
My sufferings are not different from your sufferings.
So the thing is that
If you are suffering from some kind of malady, it may be a land order malady, it may be some kind of religious oriented malady, it may be some kind of a minority induced what we call fear malady, it may be other kinds of what the majoritarian malady may also be there. So basically, when we are talking of humanity, when we are talking of sufferings and pain, then there should not be any kind of a difference. When there is no difference between my bodily constitution, if I am speaking biologically, if there is no difference between your constitution and my constitution, how can we what you call make any kind of a difference on the basis of tangible or intangible items?
So the thing is, I never had to be in pain to. I never came from a place where I was made to worship or made to do anything. But now I even used to think that wearing hijab was something like very sexy or comes under sexy. But now that I understand that it is your choice to wear, and they should be granted what they want to do with their dressing or what you want to eat. It's their choice. Now I understand that preamble must respect. It must be individualistic as well as it must have. Preamble must be consent based. It needs to provide consent to the citizens. Yeah.
I immensely appreciate your participation, and definitely your class participation is going to be incentivized. You will see in the coming weeks what kind of incentives are going to be if that is why I always encourage, and I would like to request my online friends, they can also share their understandings about the preamble and what has been their personal experiences so far, the application, execution, enforcement of the preamble, particularly in their respective jurisdictions. So what has been, as a student, as a scholar, as a family member, as a member of the civil society, how they perceive the idea of preamble to the constitution or the preamble to some of the important religious scriptures, because I feel that whether we are studying the Rig Veda or the four Veds collectively, then definitely I find them as the constitution of the humanity and its existence. If I am studying Holy Quran, I feel that I am reading a constitution again, because that is also addressing each and every aspect of the human existence. Whether I am reading Gita, I also feel that I am not reading any kind of a religious scripture. Again, I am reading a constitution, and that is very, very necessary. I should what you call benefit myself. I should cajole and rummage some of the beneficial what you call remedies to what you call redress some of the important what you call grievances which we are confronting so far. Our enjoyment as a as a human being within the four walls of, civility, dignity, and probity is concerned, and whether if I am, using or, studying the constitution of, Pakistan, then even the, honesty related, provisions have also been incorporated, probity related provisions have also been incorporated. Even the constitution of Afghanistan, Islamic Republic of Afghanistan, that makes it critically, clear in its what we call, very first provisions, that anything which is going to be inconsistent with the Islamic what we call, tenets and Islamic, injunctions, that should be construed as a null and void. That would be inappropriate, and it is not going to be what we call, regarded as a part of the, constitutional, scheme. That kind of, understanding we generally witness in our, understandings in our, preamble to the, respective, constitutions. So let us have a larger what we call, perspective. We should not simply say that the Bible is a religious book, or the Holy Quran is a religious book. No, or the, Gita is a religious what we call, scripture. No, we have to what we call expand our, horizons of intellectual, wisdom, and try to understand that many of the, fundamental principles or relating to the humanity and human existence have also been incorporated and taken from these, scriptures and incorporated in the modern day constitutions. So this is how we should, try to understand the entire, preambular propositions. Though we may have some kind of a, religious understandings, and that is why it becomes necessary to understand, because the larger what we call, perspective of human integration or humanity assimilation should not be, forgotten, and that is why it becomes relevant, imperative on our part to understand how the constitutions have been what we call, designed in Muslim nation states, what has been their, past practices, and what kind of, options are available to them so far their future engagement with constitutionalism or constitution making is concerned. And that is why I have given you an example of what we call a city state. Medina, for the first time, a constitution was adopted by the Prophet himself. So you can understand, because this constitution was framed and put into effect with the full what we call, consensus of not only the followers of the Prophet Muhammad, but also hundreds of the fellows, and gave the details of the rights and duties of the ruler and the ruled, as you have also pointed out, that it must what we call take into account civil and political rights. I mean, you have used the word individual rights. You are talking of Sarka. So preamble, when we are talking of justice, if you take into account the preamble to the Constitution of India or the preamble to the Constitution of Nepal, you will find that in the context of what we call of it is not talking in terms of rights. It is not talking what we call other important destinations. No, it is really talking in terms of duties. It is talking in terms of dreams. It is talking in terms of ideas. It is talking in terms of fundamental what we call goals. Like, and that goal is known as, if I invoke the idea of Professor Amartya Sen, transcendental institutionalism, it is talking of the transcendental institutionalism, my dear friends. It means it is talking in terms of justice. Justice of a political character, justice of a cultural character, justice of a economic character. It is basically talking of certain important what we call institutionalization and institutionalism. When we are talking of equality, when we are talking of liberty, when we are talking of fraternity. So it is not at all, we should not feel that this trinity, equality, fraternity, and liberty, this trinity we have received from the French Revolution. No, we are going to be very myopic. Rather, we should have some kind of a larger what we call. We should not take some kind of a long view. Rather, we should have some kind of a bird's eye view. That sort of understanding should be reflected. So preamble to each and every constitution, when we are talking of the aspirations of a particular geopolitical entity, are reflected in the preamble. The dreams of a geopolitical entity are carried and clothes within the rubrics of what we call the preamble propositions. So that is the importance of preamble, and that is why, my dear friends, it is necessary how the Muslim nations have been drafting. And before what we call I proceed further, it is equally important, my dear friends, how we have been dealing with these kinds of democratic future options so far, the making of the preamble or the designing of the constitution in Islamic nation states. Muslim theologians, my dear friends, Muslim or Islamic scholars, how they have been interpreting the rights. So we do not find any kind of a similarity. We do not find any kind of a unity of thought, because the different schools have taken different yardsticks, different what we call religious leaderships, or the concept of what we call of imams. In your LLB days, in your respective jurisdictions, you might have studied, my dear friends, those who are hailing from South Asia, including the Southeast Asian nation states, including Central Asian republics, you will find in this particular part of the world, we find the persons of the Hanafi interpretation of Islamic scriptures, Hanafi school of law. It is one of the allegations, political allegations from some quarter, that the Taliban is basically, follows the ideology that has been preached in Darul Uloom Deoband. It is a highly what we call, misplaced kind of, orientation. And sometimes it is also alleged that it is basically the ideology of the Nadwatul Uloom Lucknow that basically, that is basically subscribed by the, Taliban in Afghanistan. No. It is basically because these institutions are also, preaching all kinds of, interpretations. This kind of a Wahhabism oriented, interpretation, or the Salafism, oriented interpretation. If I'm not what we call subscribing or, naming these kinds of, heavy, value loaded, words, which have been named after of those very personalities who have propagated this kind of interpretation. In other words, as a student of interpretation of the statutes and legislation, we can call them only on the basis of one rule, and that is the Puritan rule of interpretation, or you may call it the grammatical rule of interpretation, or the literal rule of interpretation. So that literal rule of interpretation is generally advanced by Imam Abu Hanifa. Almost hundreds and hundreds of years later, after the demise of the Holy Prophet Muhammad. And in your Muslim law books, you have studied 4 Imams. Imam Abu Hanifa, Imam Shafi'i, Imam Malik, Imam Hanbal. So they have established different schools of jurisprudence, which is known as in Arabic Islamic fiqh. Fiqh means, it's a Arabic word. Fiqh means jurisprudence. Vidhi Shastra, what we call in Hindi. So if you take into account these interpretations are reflected in the state transactions or the businesses which are generally carried out as per the Quranic injunction or the Quranic ordinances. And they have designated their constitutions as Islamic constitution. So they have inserted, my dear friends, because Muslim majority nation states are having a different kind of orientation of sovereignty. Because in Islam, sovereignty rests in Almighty Allah. That is their what we call understanding. And they feel, as per the Holy Quran, my dear friends, that Allah alone is the repository of sovereignty. And that is why the institution of caliphate emerged, or representative democracy. All kinds of principles, the principles of what we call of sociology, the principle of democracy, the principle of other what republicanism, the idea of cosmopolitanism, and idea of rights of minorities in Muslim majority nation states. You will find that these chapters are there in Holy Quran, including physiology, astronomy, math, algebra, everything you will find in Holy Quran. Separate chapters have been attributed. But see the role of what we call of these interpreters. Entire Holy Quran, with due apology and due regards, I'm not here to hurt the feelings of my friends from South Asia or beyond South Asia. If you recall, a moment ago I have spoken something else, that I study Vedas, I study Gita, I study Bible not as a religious scriptures alone, but unfortunately Holy Quran has been confined as a religious book alone, and that is not the case. There are very few, my dear friends, very few chapters and holy verses in the Holy Quran which are basically confined to what we call worshipping, namaz, or what we call in Arabic salat. Very few what we call. Rest of the provisions, rest of the chapters are exclusively devoted to governance, to other important what we call areas and disciplines, which I have just mentioned. But what we have been doing, I tell you, in Aligarh Muslim University, whenever I visited any mosque and I wanted to offer prayers, so generally the student community do not support any kind of a care. Without care, the student community and largely they offer prayers. Same thing I was doing in the mosque of my village. One rickshaw was also there in the mosque. He immediately took a care from the Almira and put it while I was offering. He disturbed me. What happened subsequently, I should not share. But this is the orientation. Because they have been taught. When I was contributing, I was the part of a discussion paper which we have submitted collectively to the Chief Justice. When this particular case was sub judice, we made a representation. I mean, various scholars from different educational institutions collectively. And there were diplomats, former commissioners, academicians, a group of almost what we call 30 people, and it made a representation to the judiciary that we feel as a literate persons from the Muslim community that this should be the nature of triple divorce, and that is the position, that is the real position, religious position as per our interpretations, as per the we have submitted. It was not exactly the representation, rather it was a consultation paper that after our consultation among ourselves, we have submitted. And on that very basis of consultation, subsequently I have also immediately after the judgment, I was waiting for the judgment, though in advance I have written something on triple divorce, and I drawn in that very article that was carried by wire. So in that particular blog, I was basically making drawing some parallels between civil and political rights which have been guaranteed by the Constitution of India and by Holy Quran. When this judgment was out, I immediately sent this very blog for publication. and it was published. So there was, in that very triple divorce judgment, you will find that there is a similarity between the Quranic idea of constitutionalism and the constitutionalism that has been ordained under the Constitution of India. Lot of similarities were there, but you can also understand, my dear friends, before this development, almost before what you call more than a month, I was waiting for a auto rickshaw outside Akbar Bhavan, South Asian University. Then after a wait of more than 10 minutes, an auto arrives, and the driver happened to be a Maulana, a flowing beard in the 50s. I took it. I offered salam to him. He was very happy that a suited booted guy with a suitcase and sporting tie and everything, and he is coming out from Akbar Bhavan and offering salam. So he took me. No, I will take you. Wherever you want to go, I will take you. That I want to go to Jamia Nagar, I told him. Yeah. I put a very first question to him, Maulana, what is your opinion about triple divorce? Maulana told me, it's a personal experience, my dear friend. You learn a lot from your surroundings. अरे साहब, जो इस ट्रिपल डाइवोर्स को नहीं मानता है वो मुसलमान हो ही नहीं सकता. Those who do not what you call accept triple divorce, they cannot be Muslims. It is an integral part of Islam. And thereafter I stopped. It was my final question as well. I kept mum throughout the journey. No, I should not talk. That is the level of what you call of awakening the real message. You will not find any mention of triple divorce in this Holy Quran. If you study Holy Quran and you are already know, my dear friends, the only two forms of divorce have been granted: Talaqul Hasan and Talaqul Ahsan. And that is why it is known as triple divorce, has been recognized by Imam Abu Hanifa as Talaqul Bidat. Bidat means, it's an Arabic word, Bidat means innovation, a later creation. So something that has been recognized subsequently and without taking into consideration the administrative and executive what you call necessity, how the first caliph, I mean one of the caliphs of Islam, because of some administrative expediencies, he recognized it as an administrative measure just to warn his what he call campaigns, the people who were basically spearheading and indulging in the spread of Islam immediately after the demise of Prophet Muhammad, peace be upon him. An administrative decision was taken into consideration by one of the righteous caliphs, Umar the Great. So he came out with this kind of during his administration some steps were taken. On some other occasion, I will give a detailed account, because otherwise I will share my own article on this particular aspect. So that really tells us about the importance of the Islamic what we call understanding. My dear friends, cumulatively speaking, the idea is that as a student of comparative constitutional law, as a student of international law, as a student of this great seat of learning that is South Asian University, as a regional what we call institution, it is our fundamental responsibility that we should be very careful when dealing with certain interpretations. Interpretation is it's a kind of a terra incognita, I should say. It's a kind of a area where we have to be very, very careful whenever we try to what we call visit interpretation. Because the entire scholarship which is available on a particular point, all kinds of what we call of approaches, all kinds of methodological frameworks must also be taken into consideration before arriving at a or subscribing to a particular view. Interpretation is very, very important. So preamble, this is the beauty of a preamble, my dear friends. That the preamble basically takes into account only one thing. It is always inclusive. It is not exclusive. It takes into account, it advocates the idea of inclusion, idea of diversity, idea of human existence, idea of harmony, idea of fundamental freedoms. Whether it is the preamble to the Constitution of the United States of America, whether we are talking of the preamble to the Constitution of Islamic Republic of Pakistan, it must what we call address the problems of the minorities in Pakistan, ethnicities, racial minorities, ethnic minorities, religious minorities, linguistic minorities, all sorts of minorities, and their concerns must be addressed, because preamble does not, even if it is Islamic state, even if it is a republican what we call state, or a religious constitution we are dealing with, because no religion deprives, because my humanity cannot be different to what you call your humanity. On this particular platform of humanity, we are one and same. Because as I have already submitted, my dear friends, we cannot what we call deprive, we cannot abandon and abdicate the idea of what we call of sufferings or pains. And that is why, if you take into account the preamble to the Charter of the United Nations organizations, it basically gives a note of caution that the succeeding generations would not be confronted. A situation, whatever we have witnessed by way of interpretation, I am enlarging my submission, that whatever has happened in Second World War or during the Second World War or the post-Second World War era, we are not going to have reincarnation of those what we call brutalities, atrocities, and those what we call massive violations of human rights or massive scale of generalized violence. So that is the basic, and it has been defined as a scourge of war in the preamble to the Charter of the United Nations organization. So you can very well understand this is the importance, because preamble to anything, whether it is a charter of an multilateral organization or a constitution of a geopolitical entity, it is basically establishes, it is basically navigates and ventilates aspirations of the people of that very geopolitical entity. This is the importance, and that tells us about, because whether it is the religious scripture, very first what we call Holy Quran tells about us, about entire what we call, that really opens up the entire what we call Holy Quran, entire what we call Gita, entire Vedas, and it is the beauty of Vedas, particularly of the Rig Veda, my dear friends, where you will find what are the rights of vulnerable sections of the society, what are the rights of defenseless people in a Hindu majority nation states, what are the rights of the minority. So there is no need of looking only up to the constitution. Even the Constitution of India has also taken immensely also what we call inspired by these what we call injunctions, which we find in the Holy Rig Veda. So you can understand, my dear friends, and similar what we call yardsticks have also been adopted by the Muslim majority nation states whenever they have designed their own what we call constitutions. So codification is very, very important, my dear friends, but there are Muslim majority nation states who did not codify, like Saudi Arabia. They also call the constitution as the basic Islamic law, and it is nothing but the Holy Quran. They transact their businesses, whether it is governance, whether it is what you call, mining, whether it is digging, whether it is construction industry, everything they what you call, they find or and try to transact on the basis of of Holy Quran. So our religious scriptures are the primary constitutions. Whether you study the Greek or Roman what you call history, or other subsequent what you call empires, or since the inception, because I feel that the idea of constitution is pre-social, pre-political, so we cannot have without studying these religious scriptures the true understanding of constitutions. Your questions now. Yeah, somebody was saying something. My dear online friends, will you contribute something?
I think it was nothing, sir. It was an issue with my microphone.
Yeah, Mr. Sayyid Naved Sadat. Yeah, please.
Yes, sir. I was just asking you about the preamble that you're mentioning, and you asked us to share our contribution with you. So I was just telling you about the preamble, that it could be a factor for making a constitution. Is that right, sir?
Yes, you are right.
Okay. Just I wanted to share that. It could be right or not.
If tomorrow, yes, you are right. I think you are from Afghanistan, Mr. Sadat.
Yes, sir. I'm from Afghanistan.
Yeah. My dear friend, if tomorrow if people of Afghanistan in a Loya Jirga, if they are going to draft a new constitution that is going to reflect all the ethnicities and races presently available in Afghanistan, then they have to adopt, before what you call writing constitution, they have to adopt the minimum common understanding. And Mr. Sadat, this minimum common understanding would be preamble to the potential constitution of Islamic Emirate of Afghanistan. So you should understand it like this. So the common minimum understandings agreed upon and having consensually, or there has been some kind of a unanimity, conformity, and consensus among the members of the Loya Jirga, this common minimum understanding subsequently would be known as preamble to the potential constitution, which is likely to be there. This should be understood like this. Any other observation from your side? Yes. Now, what is your reaction? What are your questions now? And thereafter, I will try to discuss the fundamental principles of designing the constitution. Yeah, please. Don't talk of emergency, my dear friend. Entire world is suffering from the democratic emergency. I don't know how many times I have answered this question. But again, I will respond to it. And before my response, is there anybody who would like to offer something?
Different constitutions
You are from Kerala. Yes.
came up in the post-colonial context, where right, enumerate post-colonial states and
Well, yes, you are picking well.
liberal democracy. They still adopted from the estimate with the
Hmm.
So actually, their own aspiration.
Well, my dear friends who are available online, there is a question in the class. Why we have a written constitution? Why this trend is there? Why this there is a fashion of having a written, constitution? Am I correct? That is your question. So your name? Yeah, Mr. Abhijit, a student of this name, has put this question to me. So is there anybody online who would like to respond to this question? Particularly, I expect a response from Afghanistan, because Afghanistan is the latest what you call country in South Asia who is always playing with the constitutions and having rejecting one constitution, adopting one constitution, and again improving upon, and thereafter again rejecting. So lot of constitutional experiences are there. So Mr. Sadat or anybody else, would you like to have any kind of response?
Yeah, hello, sir.
Yeah, hello, you are audible. Yes, please go ahead.
I'm Riza. My answer to this question is this: that in one country, if we don't have constitutions, then there is nothing to judge based on that, the legal and illegal actions. We cannot judge by the religions. For example, in one religion, we have many sects, and different sects may have different interpretation from one thing. Then by constitution, we can clarify what is legal and what is illegal. And it is adaptable for the all persons that they are in one country. And from the other side, we cannot find anything that all persons agree on that. For example, we without law, there is nothing. Religions, sects, any other thing cannot be the source for judging that actions are legal or illegal. Then we should agree on one constitution, and based on that one, we should judge those actions that it is legal or illegal. And we Afghans cannot find that constitution. Oh, thank you, sir.
Yeah, very good. Fantastic, brother. Thanks a lot. Yeah.
Also, written constitution needs amendment to change. So, amendment cannot happen overnight. It is a process. For countries like us, we need to have written constitutions because, in case of autocratic ruler or something that might happen overnight, we need something rigid to protect us from the overall.
So I would like to add to Sridhar's point and say his point from Afghanistan. So basically, the one of the earliest modern Indian constitution was from America, and so Americans didn't develop those kind of conventions and practices which were developed by Britishers. So since 1900, so they had very old practices and conventions. Americans didn't invent themselves, they were also colonized, just like Snita said. And also, sir, we Indians, we have forgotten our ancient customs and conventions as we were colonized by the different persons. And also that friend from Afghanistan has also said, we also didn't have anything common between us. We couldn't agree to a single point until and unless that rule of law is written. We were in habit of following certain rules. So, when the countries were decolonized, then they were developing in nature. They were still learning, and so they found it very easy to write down a rule and to follow that rule, and to make it applicable to all of the people. And maybe there were amendments. There was scope of amending the rules, but still those amendments were written down so that all of the people who are just following like a sheep, they can follow. The rules and conventions were written down.
Yeah. So I think it also depends upon the people of particular country. For example, if we take England, then like we can say that the politicians are also.
What is your name?
Sir, Amit.
Amit, yes.
Sir, I think, sir, their politicians are also very honest. They rarely,
Yeah, politicians.
politicians and people,
Hmm.
they are also very honest to their convention, to the theory of state and everything they've written. But in India, especially in our region, in South nations, sir,
Politicians are equally honest.
no, sir. Like the leader of, like, sir, in constitution we have this provision of like deputy speaker in Lok Sabha. It is given there that there should be a deputy leader in that deputy speaker in Lok Sabha. But still it's already 2-3 years, but we do not have that. So we can easily violate our constitution, whether it is written or non-written. So it is good that we have written constitution so that the court can interpret it and court can enforce it.
Right. We are talking about at the 2009. Thereafter, they adopted a kind of point that was colonized. They also the government was working there without the written constitution.
Since the written constitution was there 1995,
So that was
it was a kind of quasi constitution.
Most of it was taken as a
Yes. It was a kind of instrument that was used to govern India, just like the present constitution is used to govern India.
It's not really right to compare it with the United States because you have doctrines like the rule of law. They had administrative tribunals, royal administrative tribunals, principle of natural justice. All of that was, even if they didn't have a written constitution, all of that was followed in a very rigid manner. So
Very consistent.
yeah, so it is same as the administrative tribunal. I think the act was, I mean, it was repeated very not around 2016, some year back. But the rulings of the administrative tribunals were as good as the written constitution. So it's not right to compare it.
Yeah, there are some certain benefits that modified constitution provides, and there are certain benefits that unwritten constitution also. I think that is the difference.
So also with the written constitution, there are always safeguards that you can come back to. Whenever there's a violation, there will be something that could be there to counter it. For instance, majoritarian amendment of the constitution, like basic doctrine, you had Article 14, violation of Article 14 led to different forms of Article 14, which is substantive form of equality, and it just with every violation there emerges a different form of. So you can always come back to your constitution, written constitution.
So I think that unwritten constitution is not that difficult to be followed in a very homogeneous situation like the UK, but in a diverse country like India, where everyone has their own customs and traditions, everyone follows different things. We need to have something written and rigid where there's not that large scope for interpretation or arbitrary decision.
So, well, I immensely appreciate my dear online friends. I have received as many as half a dozen responses to this particular question initially asked by Mr. Abhijit. And meaning of Abhijit is that there is a legitimate victory. It's a sanctified victory. That is the meaning of Abhijit. You can correct me. Yes, we are on the same page, and I immensely admire your intellectual wisdom, my dear friends, that at least we are able to understand the importance of a written constitution, and at the same time the legitimacy as well as the validity in terms of implementation, in terms of complementarity, in terms of other important facets of a constitutional character, the importance of an unwritten constitution. But ever since the inception of civilization on this beautiful planet, we have been, and majority of the nation states have resorted to have a written constitution because of, administrative continuity, constitutional stability, peace, and political tranquility. Because of these reasons, initially, so far the normative framework of having a written constitution is concerned, these were the facets to have a written constitution. There is another important dimension to it, and the dimension, my dear friends, is that in case of any kind of a repugnancy, any kind of an ambiguity, any kind of a ambivalence or inconsistency, then the judicial wisdom should correct. A corrective course of action must also be ensured, and it can only be ensured when something is there in black and white, duly codified and sanctified by the sovereign will of a geopolitical entity. And sometimes the sovereign will is of the people of a particular geopolitical entity, and in certain situations, in case of monarchy, oligarchy, it is the a select few, or a kind of a crony governance, or some kind of a coterie. So in that kind of a situation, but something should be there in black and white for interpretation and for what we call determination. And therefore the written constitution is basically determines the province of governments. It is not the political establishment that grants anything, rather the power structure that has been envisioned in the written form in the four walls of a constitution. So therefore, when there is a question of interpretation, when there is a question of adjudication, it is basically the limitations which have been contemplated, how to operate, how to transact, how to to do business, and how to respond in a given situation, that comes out of the constitution. And that is why the idea of supremacy of the constitution becomes important in a context of a written constitution. Other important response which I have received, my dear friends, and that is in case of written constitution, unwritten constitution. Our friend was talking, Mr. Amit was talking of that there is consistency and there is a constitutional maturity. Our a girl, she was talking of the argument. She has given an argument of homogeneity. Initially, even the English society was heterogeneous, not homogeneous. I take you back in the year 27 AD, 28 AD, and subsequent years. This entire land, which is today known as UK, or we call generally Britannia or England or Great Britain, it was not so homogeneous. There were aboriginal people, tribals were there, and there was a lot of conflicts. The people crossing English Channel, the people from Denmark, the people from Germania, the people from other what we call regions, from Scandinavian nation states of the modern what we call concept of the Scandinavian nation states, they were flocking over there and entering into some kind of a brutal spa. So it was initially, when the civilization has started, it was not a homogeneous nation state. Lot of heterogeneity was there. And there were at the same time many heterodoxical questions as well. So when civilization has attained its what we call pinnacle in the subsequent what we call years, that the constitutional conventions have started to develop. And therefore, my dear friends, I do appreciate that there should be a written constitution, and I am one of the advocates of a written constitution, because when the people of South Asia are vertically and horizontally truncated, when there is no unity of thought, when there is a war for the tribal supremacy or religious supremacy or caste supremacy, in such a situation we require legislative stability. And the legislative stability can only be provided by a written constitution, because it makes the task of the judicial establishment easy. At the time of adjudication, at the time of what we call of interpretation. Even in some of the legislations, and I agree with you, my dear friend, as you have mentioned the Government of India Act of 1919 and Government of India Act of 1935. They were not merely the legislations passed by the British Parliament, but they were basically the constitutional orders. Because our South Asian constitutions very significantly, very largely modeled on the basis of these two important legislations passed by the British Parliament, including the last legislation, Indian Independence Act of 1947. And even today, in your class of jurisprudence, you might have studied, when we are studying the sources of law, then the strongest source of law happens to be the legislation. Because again, there is a question of what we call of stability. Because legislation provides not only the political stability, but we require economic stability, we require cultural stability, we require cultural continuity as well. And it has been made possible only because of legislation, or in other words, let me put it like this, because of our written constitution. That is the idea, that is the importance and significance of the written constitution. Whether we violate it, whether we subscribe it, whether we uphold it, but a written constitution should be there. At least, because when something is written and that is violated, then only we can fix the responsibility, we can ensure the accountability. We can ensure the endurance. We can look up to the constitution of our geopolitical entity as a Pakistani, as an Indian, as an Afghan. Yes, there is a constitution that ensures what we call accountability. And that is why, my dear friends, supremacy of the constitution is important. It is not the supremacy of the governor or a secretary. That is not at all important. It is not the supremacy of the prime minister or the council of ministers, or the supremacy or the centrality of a minister. No, that is not at all important. It is the supremacy of the constitution. Prime ministers, presidents, governors, secretaries, they are merely the custodians of the constitutions. And when somebody is plays the role of a custodian, he is simply what we call presiding over the implementation of the constitutional spirit. In written constitutions, my dear friends, constitutional ethos and spirit becomes the convention, because that is not at all written, rather it is carried with the provisions. It is equally important to mention at this stage, my dear friends, that everything cannot be written in the scheme of a constitution. And that establishes, my dear friends, the relevance, organic character, evolutionary value of a constitutional document. Universal Declaration of Human Rights can be or could be an example in sight. It provides the normative framework for human rights, a common minimum understanding, as I was talking and advocating to my Afghan friend, a common minimum understanding for the preservation and fostering of human rights that has been agreed at international level in the form of UNHCR. So similar is the case of preamble to the constitution. It is the normative substantive understanding of the collective wisdom and placed as a preamble to the constitution. That is the importance of the preamble to the constitution, and that is why we require a written constitution. Because the personal whims and maxims cannot be the sole basis of interpretation. There are, people, there have been, judges in India who have given a different kind of, judgments. Subject matter that was, sub judice before them was different, and the judgment has been, different. A different kind of a judgment. Suit has been, litigated for the partition of, Muslim joint family property, and the judgment has been delivered on triple divorce. There is a judgment of this nature. There are, judgments in Uttar Pradesh. Muslims are in majority. What would you do? What kind of a judgments we have been, delivering? Therefore, if you contemplate a situation where no written constitution, or you simply remove all the constitutions from South Asia and then see the fate, destiny of the South Asia. On daily basis, we the people of India are in violation of our respective constitutions. Then might is a right kind of a situation would be there. That is the reason we require. If there are no rules and regulations to conduct the business of this class, then what would be the fate of this class? If you simply stand up in the class now and remove me from my place and you start, talking, no, we know the better, You have only one what we call, understanding of what is preamble, but we are 27 and we are having 27 understandings. So we will prevail. So, my dear friends, in modern times, in modern what we call, concept of, geopolitical entities, or for the, sake of, existential survival of this humanity divided into different geopolitical entities, we ensure the well-being for all, and it can only be possible to have a written, constitution. And that is why we are having this substantive normative understanding before the constitution, or before beginning the constitution, and that is known as a preamble to the constitution. I will continue. Yeah. Thank you very much. Let me conduct your attendance. I will, on the next occasion, day after tomorrow, I will conclude my submissions, and we would be, covering the entire, making how the what people promulgated.
Excuse me, sir.
Yeah, please.
Sir,
Yes.
can you please send us the last lecture and today's lecture at email ID, sir?
Well, the data is very huge, so I would not be in a position to email you anything, but I would, upload it on YouTube. So, and I will share the link with you, but it is very difficult even to upload a data of what we call that runs that run into 2 hours, or sometimes a little bit less, 2 hours. So, but I will try to share with you. Let me receive it.
Thank you, sir. Thank you.
I'm still waiting
Thank
for
you,
the last class data as well. Yeah, please attend to your roles now. Mr. Anmol Singh.
Yes, sir.
Miss Alaknanda Mishra. Mr. Abhijit Kumar Pandey, you are here. Miss Sumaya Muhammad Ahmed. You are from India or Bangladesh? Okay. Mr. Abhinav Pandey. Mr. Pratik Tripathi. Mr. Pratik Tripathi. Miss Bakshi, you are also here. Mr. Ramit Jain, you are also here. Mr. Ankit Kumar. Mr. Abhishek Prakash. Miss Kharda, you are also here. Your name is very heavy. Your surname is very heavy. Yeah. Okay. Okay. Mr. Nikhil Mishra. Mr. Siddharth Kumar Jha. Miss Archana Singh. Mr. Anantha Padmanabhan S. Am I correct in my pronunciation? Yeah, again it is, I will, Handungi Yasang Hansana Parera. Yeah. Yes. Miss Dilogini. Sinigdha, Miss Sinigdha. Oh. Thank you very much for your participation today. Yeah. Miss Iftisham Islam. You are from Bangladesh. Yeah, dear online friends, please attend to your roles now. Mr. Anamuddin Noori.
Yes, sir, I'm hearing.
You are here. Okay.
Yes, I'm here.
Miss Mehbooba. Miss Mehbooba Yusufi.
Sir, I'm here.
Okay. Thank you. Mr. Masiullah. Mr. Masiullah. Yes, you are also.
I am here.
Mr. Raza Mohammadi.
Yes, sir, I'm present.
Okay,
Thank
Mr.
you.
Raza Mohammadi, you are also here. Sayyid Nabid Sadat, you are also here.
Yes, sir, I'm here.
Yeah, Mr. Bhagwan Das, you are also here.
Yes, sir, I am here.
Dilip Singh. Are you there, Mr. Dilip Singh?
No, sir, this network connection he dropped, sir.
Okay. Thank you very much. See you day after tomorrow,
Thank you.
my dear friends. Take rest now. Thank you very much.
Thank you, sir.